I'll shorten and simplify the very interesting careers of both our speakers by just saying that they are both very committed, pro-democracy Hong Kong politicians, and at the same time highly qualified lawyers. Now, they also both told us that they had a rather short night because they were checking the results of the elections for the Electoral Committee, and the results, in case you don't know, are actually very strong, stronger than ever for the Pan Democrats, who won 325 seats. Of course, because of the surprise announcements by the chief executive last Friday not to seek a second mandate, I have a feeling our Q&A may extend a little larger than the initial topic of this debate. But let's first get on with our speakers and today's topic. And I would invite first Mr. Ronny Tong to give us his presentation. Thank you.
Well, good afternoon, everybody, and thank you for that very glowing introduction, which I'm sure I don't deserve any of that. Before I start, I have two confessions to make, and I beg for your forgiveness. The first is that, yes, I did get up 3:30 this morning, and then I lost my election. So if I looked a bit tired and edgy, you will forgive me, I hope. The second confession is that this presentation here, in fact, was prepared, I think about 2 weeks ago, and I didn't have time to update it. And everybody knows that in politics, 1 day is too long, let alone 2 weeks. A lot of things that happen, and we were just talking about the last talk here by Chris Patton. He came here to talk about Brexit. Nobody, apart from this room, read anything about Brexit or what he said, but only about what he talked about independence. He took a hard swing at some of the young people. That's what the reporters, your friends, of course, reported. So I fear maybe today is the same. But nevertheless, I hope you would bear with me to talk about a topic which some of you may think is a little bit out of date, but it's still, I think, good to get on with some legal argument behind this debate. And when I prepared this presentation, I did it entirely from my capacity as a lawyer and not as a politician. And again, I think I need to qualify that before I start. So let us start. Gosh, I can't read that. That's too far away. Oh, in front, right. Yeah. Okay, good. Thank you so much. Of course, it's in front of me. Right, okay, this is the fifth interpretation within the last 20 years. One legal academic described it as a nuclear bomb. I think that's a little bit exaggerated, but by no means it was not a thing which shocked a lot of people, and I think made a lot of people uncomfortable. So how are we going to make all of this? So what I'm going to do first of all is to quote you or try to summarize the 5 main points that you find in the interpretation, and how does it compare with actually what is happening on the ground in Hong Kong. Now, the first point in the interpretation is that oath-taking is a legal prerequisite and required procedure for all public officials in taking office, as well as for standing for election. Now, that, in fact, is exactly what Article 104 said. And if you care to look at sections 19 and 21 of the Oaths and Declaration Ordinance, they say much the same thing. Now, if you look at section 40, subsection 1b, I don't expect you to look it up, but I hope you will trust me that when I try to summarize the effect of that subsection in the legal counsel ordinance, it does say that if you don't comply with this prerequisite, you have no qualification to be nominated. So if you can't be nominated, obviously you can't become a legislator. Now some, I think Dennis here may take a different view. Some say that requirement is merely a formal requirement or procedural requirement and not a substantive requirement. But that is a matter which is capable of academic legal debate, but I think as to date, the court has already said that this is a substantive requirement and not a mere formality. Now, as far as the second point is concerned, it was said that the candidate must comply with the legal requirement in respect of the form and content, and the oath must be taken sincerely, so solemnly, and must accurately, completely, and solemnly read out the oath prescribed by law. Now, this is almost exactly what Mr. Justice Hartman said in the previous case, a case involving long hair, concerning the taking of oaths for legislators. In fact, I think both the Court of First Instance and the Court of Appeal both rely heavily on Hartman's decision. Section 16 of the Oath and Declaration Ordinance also makes it clear that the oath must be in the form as set out in Schedule 2. So, again, there is nothing new there. Now, the only thing new is to say that the oath needed to be taken sincerely and honestly. But I query whether that is something new, because I in fact, took the opportunity to look up the meaning of the word oath in Webster Dictionary, and those words came out in the definition. And so I would say that when the statute says taking the oath, the statute doesn't mean taking an insincere oath or not a solemn oath, but exactly what it means in an ordinary English dictionary. Now, the third point is that if the oath were not taken sincerely or solemnly, then the person in question must be taken as having declined to take the oath, and he or she was to be disqualified from taking the oath forthwith. Now that, in fact, again, is essentially what Section 21 says. Section 21 says that if, when you're being asked to take the oath and you declined or neglected to take the oath, then you will immediately be disqualified. What is meant by neglected? Well, I don't think it means negligently. It must be read as sui generis with the word decline, which means that it has to be done neglected with intent. And indeed, that is exactly what Judge Au said in his decision in the first instance. Now, the other thing is that people may question, well, that's a bit harsh, isn't it? I mean, you know, after all, these people were elected by the people of Hong Kong, and they have no less than 20 or 30,000 votes behind them. Well, I think politically that probably is right, but I think the proper thing to do is not to ignore what is said in Section 21, but try to repeal it. Or alternatively, try to take out a judicial review and say that Section 21 is contrary to perhaps Article 26 of the Basic Law, which says that everyone in Hong Kong, of course everyone with permanent right of residency in Hong Kong, has the right to elect and be elected, and therefore whether Section 21 runs foul with Article 26 of the Basic Law. But again, even that argument, I think, probably has been rejected in effect by Mr. Justice Au and the Court of Appeal. And of course, if you want to challenge that, who knows, you might invite another interpretation on what is the meaning of Article 26. So I would really caution anyone who thinks that he can get somewhere with challenging Section 21. Now, the fourth point that you find in the text, oh, mind you, I haven't said it. When I refer to the text, I'm referring to the English version of the interpretation. I bet you probably don't know that there is an English version, but there is. I haven't actually checked word for word whether the English version is exactly the same as the Chinese version, in translation. But having been through both versions, I think they're more or less the same. But I have to leave you with a caveat that I haven't actually checked, or I haven't asked a professional interpreter or a translator to check whether the English version has exactly the same meaning as the Chinese version. Now, back to the fourth point. The oath must be taken before someone authorized to administer the oath, who must determine if the oath was in compliance with the requirements of the law. Now that, again, is exactly what Section 19 says. And Section 19 says that, you know, before you have a president in Legco, then the secretary would take the oath, or administer the oath, but when there is a president, then the president would administer the oath. The law doesn't say anything more than that. But if one remembers that the Oath and Declaration Ordinance is a general statute dealing with all oath-taking and all declarations in Hong Kong, and not just oath-taking and declarations in Legco, then I think the meaning probably to be given to the task of administrator would be the same as other administrator in other fields when they administer oath, for example, a notary public. And I think in law that means that that person's duty is administrative and not legal, in the sense that if he decides that an oath is invalid, that decision is open to challenge by the courts. And in fact, again, this is exactly what Judge Au, and I think more so in the Court of Appeal, who said that, you know, if and when there is a debate as to whether the administrator had properly administered the taking of oath, then you ought to come to the courts and let the court decide. And funny enough, I think on the first occasion, when all these problems started, I think the secretary of Legco did make some mistakes. There are some who I would think, if I were the administrator, I would not accept their oath, and some that I would, which he didn't. So unfortunately, that's how it works out in real life. But as I say, although the law doesn't say who administers the oath must determine if the oath had been lawfully taken, it must be presumed that in law, and if in doubt, then the court must be the final arbiter. And indeed, that was what the court said. And you know, when I prepared this, the Court of Appeal had not, in fact, delivered his decision. But since then, the court has confirmed what I said here. Now, the interpretation also says that there would be no arrangement to be made for the retaking of the oath. Now, that wasn't said in Article 21 of the Oath and Declaration Ordinance. But what it did say is that upon being duly requested to take the oath, if you decline or neglect to do it, then you will be disqualified. So although it didn't say that you can't have a second go at taking the oath, the law in fact says exactly that, because the law refers not a general state of affair, whether you would refuse or neglect to take the oath, but on a specific occasion. And on that occasion, if you fail to take the oath, then I'm sorry, you're out. So that is in fact the effect of Section 21. And if that is the effect of Section 21, there will be no second chance. And the president of Legco, no matter how respected he is, has no power to reconfer a qualification to somebody who has already lost it a week ago. And the law doesn't, in fact, give the president any power, any legal power, to administer the oath a second chance. I mean, the president, again, although he's the president, is not an appeal court from the secretary. So if the secretary has already made a decision, it is not for the president to correct it, but for the court to decide if the secretary had made a mistake or not. Now, the fifth point that was covered by the interpretation is that if an oath taker takes a false oath or acts in breach of the oath, then he must bear the legal consequences in accordance with the law. Well, that is stating the obvious. If somebody falls foul of the law, then obviously he has to take the legal consequence. But the interpretation didn't say what consequence that would be. For example, in the Basic Law, there is a consequence spelled out in, I think, Article 79, which said that if you acted in breach of your oath, then you stand the chance of being kicked out of Legco, provided you get 2/3 majority in Legco. Now that's check and balances for you. And the interpretation didn't say, for example, that Article 79 is no longer applicable. So the fifth point is no different from any of the 4 points that we have gone through so far. It doesn't add anything. It only, I think, spells out the legal position a little bit clearer for people to see. Other than that, I don't really see it adds or subtracts anything from what is the legal position in Hong Kong. Now, here I refer to Article 79, paragraph 7. We talked about disqualifying a legislator if he were found to have acted in breach of the oath. But at the same time, in that article, there is a requirement that you ought to have 2/3 majority in Legco before you can do it. Of course, in the present makeup in Legco, that is practically impossible to disqualify a legislator, given the fact that the Pan-Democrats holds more than 1/3 votes in Legco. So again, there is nothing new. Now, having been through all the 5 points, and I can just sum up very quickly and stating the obvious, that the interpretation is not changing the law in any substantial way. Indeed, it doesn't appear to be anything in the text to suggest that it is inconsistent with either the local statutes or the decision in Hartman. Now, so if the interpretation doesn't add anything, then what is its effect? I think we must understand the common law canons of construction of a legal document. Now, words bear, the first point is words bear their ordinary everyday meaning. So an oath means an oath. It doesn't mean an insincere oath or untruthful oath. All the paragraphs or sections of the document must be read together, and it must be presumed that they present and constitute a coherent, complete regime, so that different paragraphs or sections will not be in conflict one with another. So when you read the Basic Law, you have to bear that in mind, even if you were applying the common law canons of construction. And again, if you read the Oath and Declaration Ordinance, you have to do the same. And words or provisions are not meant to be futile or meaningless, but have substance and serve a purpose. And that also is true. So when you look at the Oath and Declaration Ordinance, it would be, I think, in law, wholly wrong to suggest that the requirements there is a matter of formality only, that somehow you can get round it by asking the President to give you another chance. Now that certainly would make the provisions completely meaningless, and that's not the way to read a statute, even under common law. Yes, I can do it within 2 minutes. So applying those principles, and the oath means, in substance, a truthful oath. We've been through that. If he says you're disqualified, you're disqualified. It doesn't mean that, well, you will only be disqualified if you still fail the second time round. And when you said that you must uphold the Basic Law and pledge allegiance, it doesn't mean that you can pay lip service to it and then at the same time promote independence, which is mutually exclusive with the whole concept of upholding the Basic Law and swearing allegiance to the SAR government. And by the same token, when you look at Article 104, it has to be read in the context of the whole of Basic Law. And again, if you read Article 2 of the Basic Law, which says that Hong Kong would have independence of judiciary, you must read that together with 158, which says that the NPCSC has the power to interpret the basic law. Now, it is therefore hard to say the interpretation has done any apparent damage, or in real terms, to our legal system. What it does is, because it's being so unnecessary, and we've been through that, everything's set in the interpretation, is already there in statute and by way of legal decision, that it reinforces the perception that Beijing is not trustworthy of our judicial system or the integrity of our judges. And that is the real damage to the rule of law in Hong Kong. Now, of course, if we compare this interpretation with, for example, the first one, that decision was given to overturn a CFA decision. And that, I think, is much, much worse than this interpretation, which doesn't overturn any decisions. And because it gives the same legal grounds to success of the government's application, it doesn't change anything. Nevertheless, it presents a damage at a time when our community is so deeply divided, and that is something that we must not belittle it or the effect of it. Now, my time is up, so I'll come back later. Thank you very much.
Thank you very much. We'll listen now to Dennis Kwok, and we'll do a Q&A afterwards.
Ladies and gentlemen, Ronny, Florence, thank you so much for coming. I've been up all night, so I sound a little tired. And I'm pleased to say that the Democrats, we filed 352 candidates in the election committee election. And the latest report is that we've got 325 seats on the election committee. And I think that is a tremendous effort on the part of the Democrats to get so many people to stand. I remember when I first stood for election committee election 10 years ago, it was so hard to actually find people willing enough to stand. But you know, we've progressed a long way, so I'm quite pleased about that. But I know I came to speak about the implications of the interpretation. This election result this morning is one of the implications of the interpretation of the basic law by Beijing, because a lot of professionals, especially professionals in my sector, the legal sector, are not happy with the decision to interpret. And a lot of Hong Kong people aren't happy either. A lot of them have a vote in the election committee elections, and they came out yesterday. The voting rate, I think, was more than 11% higher than last time, and really shows that one of the implications of the interpretation is that it has energized a lot of people, especially the Democrats, to come out and vote. Now, in contrast with Ronny came here as a lawyer. I came here as a politician. So allow me to focus my speech more on the political implications. You know, before our lunch, a lot of you came up to me, asked me about what's the inside story about C.Y. Leung's sudden announcement. Seriously, I don't have the inside story, but I can, you know, focus my content of my speech more on the politics, because I think it is important not to lose sight of the politics. This whole interpretation of the basic law by Beijing is a political move. No question about it. It was done with an overt political goal in mind, which is to stop the pro-independence lawmakers from entering office. It was clear as daylight. They've said it themselves. And this is why they've done it. They were angry. Beijing officials would tell you that they're very angry at the two, who, in my view, were irresponsible and childish in what they've done. No question about that. But there's also no question that this interpretation is about politics. There's no real dispute over the meaning of Article 104, and as Ronny has summarized the legal principles, I mean, the law is quite clear, and this interpretation doesn't really add anything to it, and it was certainly unnecessary in terms of resolving the so-called legal disputes before the court in the judicial review proceedings. And in fact, the judge said that he didn't need refer to the interpretation. And it was as clear as that. But this interpretation was a political message that we will not allow pro-independence lawmakers from taking office. Now, I remember I was in the courtroom the night the government went to get an injunction against the president of the Legislative Council. I was there. to sit in on the proceedings. And Johnny Mok SC, who was representing the government, said this. He said, these people, referring to Leung and Yao, these people should not be allowed to take office, not for 1 minute. Now, I think that submission, in my view, summed up the whole so-called oath saga, the interpretation by the NPCSC. You know, when I took my oath of office this term, I did it in English. As you can tell, I don't have a funny accent. This is my usual accent. And I thought it was all fine. You know, I thought that my oath was all okay until this interpretation came along. And my friends in the pro-establishment side told me that, hey, Dennis, you know, the China Liaison Office is seriously looking at your oath. I said, my oath? What's wrong with my oath? Apparently, I've added words into my oath without me even knowing. That apparently I've added the word, instead of saying serve the Hong Kong Special Administrative Region, I've added the word to serve the Hong Kong Special Administrative Region. And I've been told I'm on the questionable list in Western that I don't know. Maybe tomorrow I get a writ served on me saying that my oath is not good. But it's gotten that, you know, it's getting to that sort of level. I think some people say this interpretation brings a lot of certainty to our state of affairs. In fact, it does completely the contrary. There are currently 4 more legislators who have been served with JR proceedings, and that's ongoing. I won't comment on it too much. But the political implications are that we may have a set of by-elections coming up in 6 months' time, probably after the chief executive election, and those elections will be just as divisive for our societies ever, because a lot of people feel that I voted in these guys and now you disqualified them and now you want me to exercise my vote again, and the arguments will be just as strong on the other side, and it does no good for Hong Kong. Politically, socially, this interpretation divides us. It divides a society that is already deeply polarized, and these by-elections coming up will be won't be pretty ones. So those are the immediate political implications in terms of the elections in Legco. You know, in the past month or so, Starry Lee, who's the chairman of the House Committee, and myself, I'm the vice chairman of the House Committee, we've been working very hard to trying to bring the temperature down a notch in Legco. So we've been working very hard behind the scenes to try to smooth things, to try to get things going again, that we will, as you've seen, we've had some normal council meetings and some very hard-working panels and committees working on a huge variety of issues. And I think, you know, sensible, good people are trying to work together and try to bring things to the normal. But every Friday night, you get some new developments. There's never a dull moment. Judicial review, writs, and then the chief executive saying that he won't run again. But there are things happening all the time. But there are, I can reassure you that there are people who's trying to get things to work. But it is difficult because the next thing, the next battleground of this old saga, which is far from over, is not the new judicial reviews that's just been served on the legislators, because that concerns the taking of the oath. The next battleground will be about whether you have breached your oath, which is covered by the 3rd paragraph of the interpretation, as Ronny has spelled out. It talks about that there will be legal consequences if you breach your oath. Now, it goes without saying, of course, there are legal consequences. It doesn't tell you what those legal consequences are, civil, criminal, or other things. Now, thanks to the Honorable Paul Che, who's a legislator, he moved a motion to be debated this Wednesday, this coming Wednesday, to seek to investigate the Honorable Zhang Chongtai, you know, that young guy who flipped over the flags and in Legco, and you know the thing. It was a silly move, you know, childish, what he did in flipping over the flags. So what Paul Che now has done is to move a motion to have him investigated and to impeach him under Articles 79 of the Basic Law, to say that he has committed a serious misconduct by doing that, and he has breached the terms of his oath. Now, no doubt, guys on the other side, the pro-establishment, would say, yes, of course he's breached the OL. He has insulted the flag, he has done this and that. And people, some scholars in Beijing would say, yes, that comes under paragraph 3 of the interpretation. He has breached his oath and there are legal consequences. And in his impeachment motion, he said that deliberately. He put in, I think, that he has deliberately breached Article 104 of the Basic Law, and that, of course, includes the interpretation. So where does it go? Things will we'll try to get things going again, but some idiot comes along and break it all up for you. In life, as in politics, there's always idiots who will try to stir things up and try to impeach this and that, because this is a very I think a bad precedent on the part of Paul, because it only takes 4 legislators to move a motion of impeachment against another. If you do it, Paul Che, you do it, you get you and 3 other guys to help you. Next week, my friends on the radical end will, impeach another, but probably Wang Dinggong, who also had problems with his oath, to say that he breached Article 104 or someone breached the oath. It's never ending. I really, looking at the situation, this interpretation has stirred up even more division, more hatred and polarization in our political culture. Far from it being that it settles things, that it brings about certainty. Far from it. So I'm afraid that we are going to be stuck with this oath business for a while to come, whilst some of us are trying to get things done in Legco. 2 minutes left. Yeah, before I finish, I just want to talk about the state of the rule of law in Hong Kong. Now, I'm not gonna succumb to this ultra pessimism that some people have, saying that the rule of law is dead. We might as well tear up the Basic Law because it's a meaningless document. No, I'm not going to succumb to that, because the moment you succumb to that kind of pessimism, you give way to populism. That people will come along to take your political space and say, oh, Dennis Kwok has retired. Dennis Kwok has given up. Let me take his political space. Let me offer some political solutions, such as self-determination or Hong Kong independence to try to solve what is, in fact, a very complex set of situation. No, I'm not going to succumb to that kind of pessimism. But at the same time, I'm not going to say to you that everything is hunky-dory, that this interpretation does nothing to the rule of Hong Kong, rule of law in Hong Kong. It does have a tremendous impact on the perception of the rule of law in Hong Kong. And if Beijing can interpret a provision in the Basic Law, which is really quite clear, and write a 3-page essay on a 1-paragraph article on Basic Law, they can do anything with any article in the Basic Law. And that is a real concern. But the threat to the rule of law in Hong Kong is external as well as is internal. Because for those of us working to try to make the system better, we know there are serious issues regarding shortage of judges. We don't have enough judges in Hong Kong. The court buildings are out of date. We need serious renovation to happen to the High Court building, etc. The legal aid system needs improvement. Those are the sort of bread and butter, nuts and bolts issue of the rule of law that we also need to work on. So let us not lose sight that, yes, there are threats to the rule of law externally, but there are also internal issues that Legco needs to get to work in trying to resolve, to get more funding for the judiciary, to hire more judges, and to improve the quality of the environment, the rule of law environment altogether. So leaving you with that thought, happy to take any questions, legal or political. Thank you very much.
My question is for both of you. There's a concept called giving someone the benefit of the doubt. I'm fairly well convinced by Mr. Tong's presentation that the MPC interpretation does nothing to really damage or affect Hong Kong law, the Basic Law. If that's the case, is it possible to look at this as a means of saving face directed principally at a domestic audience and carefully crafted not to damage the Basic Law?
wants to reply?
Well, Beijing is not the most transparent administration in the world, so I think it's very difficult to understand what exactly did they want to do. In fact, I've been fighting very hard over the last few years trying to get the whole interpretation business to become more transparent, more open to participation by people who are being affected most, i.e. us. But I think this is a political move. But then all interpretation on constitution must be political, because constitution itself is not a pure legal document, but a political document. I think Beijing is really afraid that the government will lose the case, which I think is very, very sad, and it speaks volumes about the failure of each other the failure of communication between each other. In fact, I've been shouting at the top of my voice for the last year to tell them we have a very good legal system. We have judges who everybody can trust, and there's absolutely no need to do this. But unfortunately, it is fallen on deaf ears, and then there we have the interpretation. And now everybody's got to pay, not just us. They also have to pay, because as Dennis quite rightly pointed out, that it unleashed a backlash of public sentiment, which in fact has given very good momentous to the democratic movement in Hong Kong. So Beijing has got to live with that now.
Yeah, and Dennis, your view on this?
Yeah, just a quick word. I think as I said, Beijing did this on pure political agenda, which is to stop the pro-independence lawmakers from taking office. And there's no stopping them, because they don't. I mean, they like control. If they think there's a 10% chance of government losing the case, then they would do it, because they want absolute certainty. I no doubt. I think the Secretary for Justice probably have told Beijing, look, don't worry about it, don't step in, we're going to win this case. But they still did it anyway. So they don't understand how in an open democratic country, you can't control everything, including court results and elections.
Can I just add this? While I think it is right that our Secretary for Justice is saying that we will win the case, in fact, I said the same thing to them, that definitely we will win. But unfortunately, there are some very senior lawyers in Hong Kong, senior barristers even in Hong Kong, who are close to Beijing, who take the view that the SAR government will lose. This is a complete reversal of roles. And of course, Beijing will listen to their own lawyers than to listen to us. That's the unfortunate thing.
Next question, over there on the left. Thank you.
Thank you. My name's Russ. I know we're starting from where we are.
Can you introduce yourself? Sorry.
Russ Harding, my name is. I know we're starting from where we are, so this is a slightly theoretical question, but nobody seems to have asked the question, is it still appropriate to have oaths in the modern context? Because I can see in certain circumstances, if you swear in court to tell the truth and you don't, there's a direct legal consequence if you're proved not to. But an oath is basically something between you and your God, as you showed on there. So practically, if you don't believe in burning in hell after you take the oath, there's not much to do with it. And all the other things you suggested that come on from that are, there's laws against them anyway. But, you can't go against the mainland Chinese government and so on. So should it be a chance to get rid of it, this thing?
Dennis first.
Yeah, it reminds me, your question reminds me of those 18th century cases in the UK where, an atheist tries to take office and refused to take an oath to God, but did it by way of affirmation. So he was disqualified, I think, several times until they changed the law to allow people to do an affirmation instead of an oath. But I think the law is clear that you've got to swear allegiance to the Hong Kong SAR. And I don't think we should move the debate to whether we should do an oath at all. I mean, I think that would be losing the point. I think the point is that you've got to declare allegiance. You are an important member of the constitutional structure. Judges, senior government secretaries, and lawmakers have to do that. I actually don't see a real problem in taking the oath itself.
But if I can follow up on this, I think there is an interesting contradiction between people standing up when we know that what they have in their mind will be to possibly change some of the basic law articles, and yet requesting from them to solemnly say that they agree on everything in the basic law. So it's
But changing the basic law is or can be done within the framework of the basic law. There is a provision that deals with amendment. So I have said many times that I don't think this is the time for Article 23. That doesn't mean I don't accept the premise of Article 23 or other articles in the basic law. But that's the thing. If I start moving motions debate in Legco calling for, say, self-determination or even Hong Kong independence, does that mean I am breaching my oath, acting in violation of the interpretation? Would I then be impeached? But at the same time, Article 77 of the Basic Law says that all statements made by legislative councillors in Legco are immune from legal action. So how is that going to read together with 104? If you ask Beijing or any of the pro-establishment lawmakers, they would say, of course you can't talk about independence or self-determination in Legco. But the other side would say, but we have the freedom of speech under Article 77. I hope that won't lead to another interpretation, but it looks like things, thanks for Paul Che for stirring more stuff up, arguments. People will, on the other side, start to move motions, debates, to call for independence or self-determination in Legco. Then what happens? That is the kind of next thing that I see happening.
Thank you. Here,
Thank you. Sebastian Beck from EHSS in Paris. What are the implications of the interpretation for the JR cases on the people who were disqualified before election? Because that will be the upcoming issue when by-elections happen. Will the people who have been disqualified allowed to rerun? Other people who have been previously disqualified? And on a minor point, neither of you mentioned Martin Lee's point about the changing of allegiance not to the SAR of the PRC, but to the PRC and its SAR. Do I gather that neither of you thinks this is very significant?
I think the position in relation to people being disqualified before election is very different from the actual taking of an insincere oath in Legco. I don't think the Court of Appeal decision would be totally irrelevant, but on the other hand, you'll be looking at a whole host of different issues there. So I think I'll be very slow to try to predict here and now what's going to happen. But if I may come back to what Dennis said just now, I agree with everything he said. And it is precisely because there's nothing you can do about anything legislators said in Legco that Beijing gets very nervous and wanted to stop these people getting into Legco. But the funny thing is that this whole thing was not engineered by Beijing. It was started by people who wanted to make fun of the oath-taking. And unfortunately, that presents an opportunity for Beijing to come in as harshly as he did. Well, that's a lesson to be learned by everyone here.
Can I just echo that? I agree with Ronny, but also let's not lose sight of the bigger picture. Why are these independents or pro-independence politicians being elected not by a few Hong Kong people, but by 18% of the voters? Now that is the question which we need to address. Before C.Y. Leung used the term Hong Kong independence in his policy address, I think it was a couple of years ago, the term never entered the mainstream political conversation that we have in this city. Why is it that now people are talking about? There's a recent survey in Hong Kong Youth, 60% of our Hong Kong students believe in Hong Kong independence. That is the point which we need to address. If we don't put one country, two systems back on track and have constitutional reform leading to genuine democracy, more and more of our young people will buy into this rubbish. And that is the problem that we will face today.
Thank you. We'll take the question from the Swiss correspondent.
Thank you. I'm Frédéric Lelièvre, Swiss Daily Le Temps. I'd like to know what the camp, the Democrat camp, will make of today's success at the electing committee. Will they tend to support or go to a pro-Beijing candidate and have some influence of his or her agenda, or will they push for their own candidate? Thanks.
Well, okay. In practical terms, I think in practical terms it would definitely worry Beijing a great deal. What Beijing would do probably in reply would be to screen out its own people. In other words, Beijing, first of all, doesn't want to rely or to make the pan-democrats a kingmaker, so that he would have to rely on the remaining some 870 votes to make sure that a loyal and trustworthy person would be elected as the next chief executive. And Beijing therefore cannot afford to have two real competitors within the same race, because if that were the case, then it would give leverage to pan-democrats to be a kingmaker. And because Beijing wouldn't want that, I think what we would see in the coming weeks is that Beijing would do everything it can to screen out some of the more likely winners. And in fact, this is already happening, because you probably have read or heard that the financial secretary, who apparently just resigned today, ran into a red light. And I think he suffered probably from the effect of the election today. Whether it's a good thing or it's a bad thing, you know, I would be very slow to commit myself at this moment. I think the pan-democrats rather should make use of this opportunity to try to talk to Beijing, because Beijing did two things which the pan-democrats had wanted to see happening before. One is to kick out CY Leung, and Beijing did. The other is to give them back the return home permit, which again Beijing did, within a span of 2 weeks. And I think that is an olive branch that nobody should ignore. And I truly hope the pan-democrats we would do something in reply and take us, a step forward in this, very unfortunate series of events over the last 2-3 years.
Thank you.
And try to make it a better situation here.
Maybe Dennis, a very quick one. I'd like to squeeze one more question from Cliff after that.
We've been in constant dialogue. Myself, in particular, have been in constant dialogue and conversation with officials in Beijing. We tell them that you can try to get rid of us, the Democrats, but you won't get our seats, because the self-determination or radical independentness will be getting our seats. So you will have a real problem. We are talking about the basic law. We are willing to talk about one country, two systems with you. Work with us. We are not your enemy, and we've never been, really. Now that you can see that tectonic shift happening in Hong Kong politics, I think one thing about the Central People's Government, they are very pragmatic. They see that happening, and they see that that working with the Democrats, or what they call the moderate Democrats, have a benefit to them. And I actually sense there is now a shift, and Ronnie's right, and we need to respond.
Okay, so we're in overtime for one last question from Cliff Bottle.
Hi, up until this interpretation, we had gone many years without an interpretation other than the one in 2011, which was requested by the court. There seemed to have been an understanding that interpretations would be delivered only as a last resort. Do you think that position has now changed? Do you expect there to be more interpretations? And are there any checks and balances on what can be included in an interpretation, the scope of an interpretation?
Well, this is a last resort as far as Beijing is concerned. They look at independence as really the most serious thing to happen to Hong Kong since the handover. So they're not taking any chances. Have we in fact seen a lenient interpretation, if there is such a thing, or that it could be worse? I really can't tell you, but I have to say over the last years, in all my discussions with people up north, and I've heard various things like, well, let's interpret Article 26, which is article to elect and be elected. Let's interpret Article 79, which is to, do away with the check and balance of kicking out a legislator. I mean, I have heard a lot of nonsense about interpretation, this, that, and the other, and when it finally came with the interpretation of 104, and having been through it with a column to try to compare with what's the law here and the cases that we have, I'm relatively comforted, if that could be a word to be used in the case of interpretation, that it has not been worse than now. One thing I regret a little bit is that the reaction in Hong Kong perhaps is a little bit too severe, which would only make things worse. As far as Hong Kong is concerned, because don't forget, rule of law is a concept. It's very sensitive, very fragile, and if people in Hong Kong internally really believe that the rule of law has crumbled, then that's the day that we regret very much. And let's not help Beijing to do it.
Dennis?
Yeah, well, the lawyers, I organize a march, as you all know. I don't like marches, but those are the occasions where we had to say something, that we don't accept this interpretation as being necessary. We are not disputing necessarily their power to do it, but we're saying that on this occasion it was unnecessary. And it is on the same, when we marched against the white paper, if you remember, a couple of years ago, people asked me why I organized a march, and I said we've got to, as members of the legal profession, got to send out this very clear signal to the world and to Beijing that we will not accept this kind of concept of rule of law, that judges have to be patriotic. We go by our own system, our understanding. You know what that is. I think it's important for the legal profession to send out that message to the world. And same with this time, that we do not accept this kind of interpretation as part of the norm. The day when lawyers, when members of the legal profession simply just sit and accept this kind of interpretation will be a very sad day for Hong Kong.
Well, we can't let you go without asking you what do you think of Wai Leung's announcement. So, as short as you wanted, but please.
I was absolutely flabbergasted. I mean, I never thought that it would happen. It's just too good to be true. When I was told about it, I think around 2 o'clock on that day, I said, "Don't be silly, it's a bad joke." It wasn't even funny. And then the joke, of course, was on me, because he did say that he's not going to run. Now, I think it's a matter of mathematical certainty that, given the fact that the Pan-Democrats would get something like 300 votes, and given the fact that Beijing probably could not stop people from on the pro-government side from running, chances of Wai Leung getting more than 400 votes are very, very low. That being the case, why persist? Why not step aside and let somebody who can really take over the situation and win, that is, get more than 689 votes, to run this election? I think that's probably the reason why. But still, nobody thought that Wai Leung would go away quietly, and yet he did. Well, that's life.
Thank you. Dennis?
Nothing to add to that, except that I was happy for about 5 minutes on Friday. But then again, I thought of all the other candidates who might come out, then, gosh. But I'm delighted that we got 325 seats, because I think that strategy worked, because as Ronny said, they can do the math. We get 300 and something seats, and politically they know that they can't just support one pro-establishment candidate to come out. Politically that would be very hard. Beijing is not God. They don't, even though sometimes they believe they do, they can't control everything. And there are pressure from different sides or different strands of the pro-establishment camp who want to push out their candidate. Different vested interest wants to have their candidate come out and run. So Beijing is looking at least 2 pro-establishment candidates running. I don't know who they are. Whether there will be a third one, I think there may be a third one, because I think all the people who've shown an interest are people who has shown a great determination in wanting to run for this job, and they will not lightly say, okay, fine, well, I'll give up. No, I don't think so. I think they're determined to run, as the financial secretary has done today by resigning. and soon others will follow. And it will be interesting to see how we can make constructive use. I stress the word constructive use of our 325 votes, both in nomination and voting. I'll look forward to casting my vote in March.
Well, enormous thanks to all this explanation. I think I'll have to listen to it again to digest everything we've learned. But as a token of appreciation, we would like to give each of you a FCC tie that you can wear at Legco. And thank you very much indeed.